honor for me to take the floor in this session and to have the opportunity to thank, on behalf of MEDEL, the Honorable Minister of Justice, the Director of the Catholic University of Portugal, our member association of Portuguese judges and prosecutors, all the participants, and a special thank goes, of course, to our speakers for their outstanding contribution, which enriched our awareness of the complexity of the challenges that Europe, the European community, the European institutions, the European citizens, judges, prosecutors have to face in the context of the attack to the rule of law. Let me just mention, among these challenges for the judiciary, the crucial importance of the legitimacy of the judiciary based on accountability, as Professor Vigano highlighted this morning. It is clear that what is at stake in the crisis of the rule of law that over the last years caused a systemic weakening of the independence of the judiciary in Europe and its sheer disappearance in Turkey, Hungary, Poland. What is at stake are rights, are freedoms. It is the very idea of Europe as a community based on fundamental rights enshrined in the charters. And it is clear that the national judges, by taking seriously these charters and keeping a dialogue with European courts, have been key actors in the establishment of the system of values that is the shared fabric of our community. These judges, who are and feel as European judges, their association, their institutional networks, the High Council for the Judiciary are now key actors in the defense of the rule of law, the content of which has been made clear by the European Commission since 2014, while designing the new mechanism to react to systemic crises in the member states. We need to reaffirm that rule of law is not simply a system where laws are applied and enforced, so not only black letter law, but also the spirit of the law and fundamental rights, which are the ultimate foundation of all laws. It is clear that the real target of the strategy we have in front of us, based on the openly declared objective to question the supremacy of the EU law and the obligation stemming from the European Convention of Human Rights, the strategy that reached its apex with the judgments of the Polish Constitutional Court last October and November, the real target of this strategy is therefore the very existence of a supranational architecture for the protection of the rule of law. Among many issues that are on the table, MEDEL wants to stress once again that public prosecution is a cornerstone of this architecture. The years-long reflection on its internal and external independence, accountability, and transparency across the variety of national systems made it possible to reach, in an extensive soft law, as we highlighted in our last session, a shared identity, a new shared identity of prosecutor based on common principle, a new identity linked to the role of prosecutor in the modern democracy, and to the shift of the paradigm represented by the increasingly supranational dimension of justice, from guardian of legality to a justice organ, promoter and guarantor of rights. It is the prosecutor who, not less than defense lawyers, can trigger in the judge who sits in front of him or her the reflex communautaire, and therefore is a prosecutor that is part of the dialogue between national courts and the Court of Justice of the European Union, and can play this role as well with regard to the advisory jurisdiction of the Strasbourg Court implemented by Protocol 16. But this new identity requires not only common principle, requires common institutional framework, enabling the prosecutors to perform their functions with impartiality and independence. In the common area of justice, which implies a constant review involving the national courts of the actual capacity of all national systems to ensure the same level of protection of fundamental rights, the capacity of prosecutors to act independently becomes one of the lenses through which one must read this radically new legal environment, as appeared clear in the case of the reference to the European Union Court of Justice for the European arrest warrant that we mentioned in our last session. And the ongoing democratic backsliding is teaching us that the institutional structure of prosecution is aggressively and strategically exploited to provide the executive power with a firm grip on the machinery of justice and on the exercise of core judicial functions. As stressed by Professor Pesch yesterday, Poland provides us once again with the most striking example with the reform in 2016 that unified the role of a Minister of Justice and that of the Prosecutor General, a reform who increased the powers of a court presidents, increased power of direct intervention in specific case, increased the external and general prerogatives of the general prosecutor in maintenance of law and order. All these deeply impacted on the separation of power and thus on democracy. But also in other contexts as well, where and when the rule of law proves unstable, it is the structure of prosecution that easily becomes the key to a covert transfer of prerogatives to the executive branch and to the pressure on judges. Let's just mention the remarks of the Venice Commission, the European Court of Human Rights on the appointment and dismissal of prosecutors in Romania, on the deficiency of the structure of prosecution office in Bulgaria, characterized by unreasonable broad powers and lack of accountability, a model functional to the merging rather than to the separation of powers in a context of huge pressure on judges. And we have to recall what has been recently said by the European Court of Justice in the case of the specialized section of the prosecution office for offenses committed by judges and prosecutors introduced in Romania. This structure must be assessed in the light of the rule of law principle and, stated the European Court of Justice, cannot become a tool to put the courts under political control. It is clear a general standard which perfectly fits to what happens in Poland with the Internal Affairs Department of the State Prosecution Service that launched action against judges who suffered serious consequences after taking decisions disliked by the leading political party. Since its beginning, MEDAL committed itself to the defense of the rule of law in Europe and within the European Union, and to the adoption of common minimum rules and standards on the organization of the judicial powers as a necessary guarantee of its independence, asking for a continuous monitoring by the European institution on the respect of these standards, as we cannot take rule of law for granted. An independent status for prosecutors is a fundamental requirement of the rule of law and fundamental instrument of the independence of jurisdiction, a further safeguard in maintaining the independence of judges, as highlighted the Magna Carta in 2010, a document that is about the independence of judges. MEDEL clearly stated this principle since the Declaration of Palermo and Naples in 1993 and 1996, recently recalling them in the Florence Declaration in 2020, constantly stressing the need for a parallel legal institutional framework for judges and prosecutors to ensure a status for prosecutors fully complying with the rule of law principle. And the establishment of the EPPO that Medel always supported should represent a major step forward towards the introduction of a renewed model of a public prosecutor well aligned to the magnitude of its role in ensuring effective and impartial guarantee of rights, the control of legality, the promotion of equality of all citizens before the law. All these principles are binding for the EPPO activities according to the regulation. Independence towards the European institution, member states, agencies, and accountability are the core feature of the EPPO, which operates as a single supranational entity, but strongly interconnected to the national judicial system through the European delegated prosecutors, who are an integral part of the EPPO, act exclusively on its behalf in the member states, and this requires functionally and legally independent status. EPPO, the EPPO, expresses our rich awareness that national judicial systems are and must be part of a broader and higher European judicial dimension. The kickoff of the activities of the EPPO will necessarily raise a line of questions concerning the interpretation of regulation, as well as the protection of the rights of individuals under investigation, and once again, as it is often stressed, the role of national courts and the European Court of Justice in developing the EPPO legal framework in a rule of law compliant manner will be crucial, but the great challenge represented by its establishment, the shift from cooperation to integration, requires the harmonization of structures and systems and the adoption of uniform rules on independence and accountability of prosecutors, if needed also at constitutional level in each national system. So it's time to implement a common European independent statute of the judiciary, as Medel advocates since 1993. Thank you.